Hello everyone, this is Anjali Sharma, Intern at ubAdvocate under Sir Jeevan Prakash, AOR, Supreme Court.
Hello everyone. So as you guys can see, today's topic is daughter's right on property. Daughter's right. So the three main elements of this topic are Hindu Succession Act, and the major discussion of this act is amendment of 2005. And the important case law which gives us clarity on this topic is Vineet Sharma versus Rakesh Sharma. So let us first start with the Hindu Succession Act. Hindu Succession Act. So guys, this act talks about succession and inheritance. This tells us who will get the property further in the family and how much rights he will have on that property. According to this act, there are two kinds of property. The first one is ancestral property and the second one is self-acquired property. So the rights of the family are always on the ancestral property. They are never on the self-acquired property, as this is earned by the man himself, not by his ancestors. This Hindu Succession Act is applicable on Hindus, Jains, Buddhists and Sikhs. So now let us understand this act through an example. The example I was talking about. So in this example, this is the ancestor who have the ancestral property. And this is his wife. And now this is his son and he have one daughter. Both got married and now this person got his grandson, and then the pattern follows same, and now he gets his great grandson, and now he gets his great grandson. Okay, so we can use two words for this family. The first is the members and the second is the co-partners. So I would like to ask you, can we call all these of them co-partners? So the answer is no. As before the 2005, co-partners were those who were the linear descendants of the same ancestors, and only the co-partners had the right on the ancestral property. So this was the example through which you guys can understand what is the ancestral property's right in the family and who have the ability to get that property. So now let us come on to the major discussion of our topic, which is the amendment of the Hindu Succession Act of 2005. This amendment crossed the previous rule and introduced new kinds of succession, which first was the testamentary succession and the second was interstate succession. This was a very simple method of succession. Here the ancestor would write the will and then the ancestral property will be distributed among the widow, the son and the daughter according to the choice of will of ancestor. In the interstate succession, the classes were divided and there were three classes. The first is of the widow, the second is of the son and the third is of the daughter. These are in the same order and three of them will get equal rights on the ancestral property. So this amendment was dated of the 9/2005. So that confusion arose when the cases came and asked whether the father needed to be alive on this date or not. So the main conclusion we get from the case Vineet Sharma versus Rakesh Sharma. So let us analyze Vineet Sharma versus Rakesh Sharma. In this case, it was held that after the amendment of 2005 Act, the right of the daughter she get on the ancestral property is by birth. So it doesn't matter that whether the father is alive on this date of amendment or not. The daughter had the right on ancestral property by the birth. So the fact of this date does not arise anymore after this latest case in the daughter's right on the ancestral property. So I hope you get all the facts of this concept and I hope you understood it well. Thank you for watching my video.